I got on the teeter, I stretched out. I felt like this is something right here. That's where it changed my life.
Discover Teeter Fit Spine, the natural back pain solution that has helped over 3 million people find real relief. Simply lie back and let gravity do the work. Teeter Fit Spine helps realign your spine, relax tense muscles, and reduce nerve pressure to naturally relieve your back pain in just a few minutes a day.
When you start stretching, you could feel like everything just ease. Oh, gosh, I feel good.
FDA registered, Teeter Fit Spine is indicated for 10 back pain conditions, including herniated discs, sciatica, degenerative disc disease, and more. Only Teeter Fit Spine is designed with a decompressive surface and integrated tools to help deepen your stretch and enhance your relief.
I just got all my movement back. I could go out, walk the dog, play basketball with my kids. It's just, I'm a new person.
Fit Spine heat-treated steel is 73% stronger and lasts 10 times longer, making it the most durable, comfortable, and effective inversion table ever.
This is steel that's gonna last forever. It's so well made, you feel safe the minute you get in it. My back feels the best it's ever felt. I can move, stretch, and do things that guys half my age aren't doing. This is the best investment I ever made on my back.
No pills, no appointments. Get natural back pain relief at home in just minutes a day. Save big on Teeter Fit Spine for a limited time at tryteeter.com. Plus, get 0 down, 0% interest, free shipping, and a 60-day return guarantee. Live more, ache less at tryteeter.com.
This is Court TV Live. We are your front row seat to justice. I'm your host, Julie Grant. Thank you for being with us on this Friday morning. This hour, we've got the father of the Georgia high school shooting suspect making his first court appearance. We saw his son arraigned just moments ago. Now, Dad is up next. 9:30 is the time they've set for it. Our cameras are positioned to go. We'll get you in there live when it begins. Also, we're ready to watch Donna Adelson return to court this morning, as it looks like this will be her final pretrial hearing before her case goes on September 17th. Before we take you into the courtroom, Court TV's Julia Janae has more for us on all of the players involved in this case.
Luis Rivera was the first person to face justice for the murder of Dan Markel. He pleaded guilty to the crime and told police that his longtime friend, Sigfredo Garcia, approached him about a murder-for-hire plot. Rivera, who was a leader of the Latin Kings, told police that he and Garcia drove from Miami to Tallahassee to kill Markel, and that Garcia was the trigger man.
As soon as we pulled in, Garcia jumped out the car and went to the driver's side. Shot him.
He shot Mr. Markel?
Yes, ma'am.
How many times?
Twice.
As part of Rivera's 2016 plea deal, he was sentenced to 19 years in prison. The second person convicted was Sigfredo Garcia. Garcia's ex-girlfriend, Catherine McBanawa, was dating a Miami dentist, Charlie Adelson, the brother-in-law of victim Dan Markel. In 2013, she was the connection between the hitmen and the Adelson family.
This New Year's Eve in 2013, were you dating Charlie at that time?
Yes, ma'am.
Okay. To your knowledge, did Mr. Garcia know about your relationship with Mr. Adelson?
Yeah.
Okay. Did Mr. Adelson know about your relationship with Mr. Garcia?
Yes.
The state alleged Sigfredo Garcia shot and killed Dan Markel, and that the money trail linked Garcia and Rivera to McBanawa, to Adelson, and his family dental practice. Garcia and McBanawa were tried together in 2019. He was convicted and sentenced to life in prison. Her trial ended in a hung jury. Then in 2022, McBanawa was retried after prosecutors were able to enhance FBI video that showed her and Charlie Adelson talking about the investigation into Dan Markel's death and about how they plan to avoid arrest.
If a badge comes up to you, tell them have a nice day, officer. Listen, if they want to charge you with something, charge me. If not, I don't talk to cops. Sorry.
The La Dolce Vita restaurant video played a key role in the case. McBanawa was the third person to be convicted and was sentenced to life in prison. Charlie Adelson is the fourth person to be convicted in the plot to kill law professor Dan Markel. Adelson testified in his own defense October of 2023 that Magbanawa, Garcia, and Rivera were blackmailing him.
They think it was a murder for hire. And
what was it?
It was an extortion.
Magbanawa and Rivera testified at trial that Charlie was the mastermind of his ex-brother-in-law's murder. He was sentenced to life in prison. Donna Adelson is the fifth person to face charges for the death of her estranged son-in-law, Dan Markel. She was arrested in November of 2023, a week after her son Charlie was convicted. She and her husband Harvey were boarding a one-way flight to Vietnam, which has no extradition treaty with the U.S.
So, Ms. Adelson, at this time, you're being held with no bond on count one.
She's charged with murder, conspiracy to commit murder, and solicitation to commit murder.
You'd have no contact with the victim's family. You'd have no contact with any co-defendants and no contact with any witnesses that are listed in the probable cause affidavit. Do you understand those conditions?
I do, Your Honor.
All right, so those are all the players involved. That was Julia Janae reporting there. Now let's go into the courtroom. We've got defendant Donna Adelson inside, her lawyer ready to go, ready to make some arguments. Let's watch.
Gentlemen, Ms. Dugan.
I already did.
Are the victim's family asking to be on Zoom once again?
I do not know the answer to that, Judge. I'm sorry. Let me confer. I think we should probably assume so. Let me confer.
All right, I see a tile labeled Ruth Markel.
Okay, then yes, Your Honor. Thank you.
Do you have any idea who Misha Janice is?
I do not.
The only reason I'm asking is because in the last hearing, someone joined Zoom who's doing inappropriate things. So from here, the Zoom is going to be limited. If I get wind of anyone else trying to do inappropriate things in the midst of the Zoom, ultimately it's just going to be, if you're here, you're here, you're not, you're not. I'll go ahead and allow all parties to make their appearances for the record.
Georgia Kappelman for the state, Your Honor. Sir, Catherine Dugan for the state.
Dan Rashbaum on behalf of Mrs. Adelson, who's present. Alex Morris on behalf of Mrs. Adelson.
Very well, let's go ahead and move with the one hearing that was scheduled for today. This is the defendant's motion in limine concerning the testimony of Sergeant Corbett and the summary exhibit. Whoever's arguing the motion may proceed.
May I approve, Your Honor?
You may.
Judge, I think we filed pretty detailed papers on this, so I'll quickly summarize, and then if you have any questions, I'm happy to answer anything that you have. I think it's very important to realize we're not asking that he not be allowed to testify. What we're asking for is two pieces at this hearing, and there'll probably be more during trial, regarding actual pieces of his testimony. So that's the third piece. The first thing we're asking for is that he not be qualified as an expert. We don't believe, as set forth in our papers, that he's testifying to anything that meets the standard of Florida statute 90.956. And so we don't think he meets the qualifications of an expert in what he's testifying to.
You mean 90.702?
Sorry, 90. Correct.
Go ahead.
We don't think he meets those qualifications. We think he is a summary witness, not an expert witness, and we think his report illustrates that. The report itself has essentially 5 components. It has emails, which are a culmination of emails that the state has taken and put in a report. Text messages, neither of which emails or text messages is he an expert on. He's just compiling them, putting them in a report. Video surveillance photos, and then it has call record summaries, which we'll get into, but takes no expertise to do the call record summaries. Florida law is pretty clear on that. As well as cell site data, but it's very limited to cell site data. especially with regards to Mrs. Adelson, who's on trial here. There's some more detailed cell site data with regards to Mr. Garcia and Mr. Rivera, but even that wouldn't qualify as expert testimony. The cell site data as to Mrs. Adelson, there really is virtually none of it. So
one question before we continue on track of the expert testimony. As it relates to items that the state can properly admit, and I'm sure there, based on your pleading, there are aspects of the current PowerPoint that are disputed as being inadmissible. But for what can be properly admitted, are you also disputing that those cannot be used as a demonstrative during trial by the state in some way?
No, they can be. So, in other words, there's no dispute that they can use the report as a demonstrative. There's no dispute that for the admissible items, they can put in the admissible items. So I'll give you an example. Email between Wendy Adelson and Donna Adelson. Clearly it's admissible, provided it's relevant. The ones they provided are relevant. Clearly admissible. The underlying email can be admitted, shown to the jury through an appropriate witness, if they call Wendy Adelson, for instance. Okay, so that email is admissible. But the summary of the email in the exhibit, the summary of the 1 or 2 page email in this exhibit can be shown to the jury, but it doesn't qualify as expert testimony or a proper summary exhibit to be admitted. Does that make sense what I'm saying?
It does. The one thing only one thing I would question, even concerning demonstrative, are you also saying the state cannot put the context around these various pieces of evidence?
No, they can. Right? They can make arguments just like they do in closing arguments. Right? They can show the exhibit to Corbett, Sergeant Corbett. He can put it on the screen. He can explain whatever he's going to testify to. Our argument is he's not an expert in doing that. That's our first argument. And our second argument is ultimately that 329 pages right now doesn't go back to the jury. It's a closing argument, essentially. When you look at his 329-page exhibit, and again, I'm getting a little ahead of myself, but when you look at his 329-page exhibit, it's essentially Ms. Kappelman's closing argument, okay, which we don't admit to the jury. The jury doesn't get her slides and see them in their jury room when they're deliberating. But no, of course, they're able to, provided it's admissible material in it. They're allowed to show the exhibit. They're allowed to use it as a demonstrative. They're allowed to question.
All right, so these hearings that are held prior to the trial can be kind of tedious, right? It can be a little bit in the weeds, but it's important because it all deals with evidence that comes in or stays out. And this is how the trial attorney knows how to fashion their case based on the evidence and the ammunition that they have got. So let's talk about what these cases are going to look like, because we know that 2 very different stories are going to be told. We've got the state story about this murder for hire plot. We've already got many convictions with this story. And then we've got the defense story that Charlie was being extorted. I think Mom and Donna's going to stick with that story when it comes time for her defense team to present. Let me bring back in trial attorney Kelly Hyman and want to welcome in Jason Piccolo. He's a former special agent with the Department of Homeland Security. He trains all the Capitol police officers. Now he's a firearms expert and author. So Jason, good to see you as well. Kelly, let's start with this trial strategy, what I was just talking about. You know, based on the rulings that we get today, the attorneys will have a good idea of how they can proceed. Do you think that the Adelsons here, Donna Adelson, I guess I should just say, Donna, is going to stick with Charlie's story about how he was being extorted by these people, he was victimized, and when she brought over that money, it was just to help him out of the mess?
Well, you're innocent until proven guilty in the court of law, and that's what's great about the American system. And so what the defense is going to do, number one, is poke holes at the state's case. The state brings the case, and they have the burden to prove every single element of the case. So they're going to try and poke holes at the case as well. And then potentially, number two, presenting an alternative story of what exactly happened, what transpired, and have witnesses that support her. But is she, in fact, going to testify? That's a $64,000 question. Is she going to testify and tell her side of the story? Ultimately, it's going to be her decision, but potentially she could stick with the story that you just discussed.
And that's really what I want to know, because it failed at Charlie's trial, as we know. He was convicted. Jason Piccolo, you know, he's convicted, but we know mad about it, doesn't think he belongs in prison, trying to exercise his post-conviction rights. And then here we've got Mom, and the two are very close. We got lots of phone calls. She wants his attorney too, Jason. She's got his attorney. Do you think she kind of has to stick with Charlie's story?
She does. She absolutely has to stick with that story. Because now, if she comes up with some other story, they're going to try to impeach her credibility. So, yeah, she's going to stick with it. And I think that's why she wants to keep the same lawyer, the same story, the same exact script that they have together.
Yeah, Donna is an interesting character, you know, because I think she never thought she would find herself in this position to be criminally charged. And now here she is going to trial, fighting this. I mean, she could have pleaded, you know, but she's cloaked in the presumption of innocence legally, and factually it looks bad. Jason and Kelly, stand by, please. We're going to hit a break. We're going to continue watching Donna Adelson's hearing, but also want to let you know we're watching things in the courtroom in Georgia, where we've got the father of the Georgia school shooting suspect set to appear in court. Why? Because he's charged too. It's just like what happened in the Crumbly case in Michigan. Now we've got another case where a parent is facing potential criminal liability because of the actions of their child.
Join Court TV's Vinny Politan.
In every story, in every trial, every case, there's at least two sides to it.
To dive into the latest.
Oh my God.
And breaking true crime stories.
This was a very targeted, very personal attack.
Inside.
I've never seen that in Discovery. I've been incarcerated 3 years.
And outside of the courtroom.
She's a psychopath.
Now, let's look at the other side of all of that.
Vinny Politan investigates. Tonight, 9/8 Central. Only on Court TV.
Welcome back to Court TV Live. We continue with our breaking news coverage. We are in Florida, and now the father of the accused high school shooter, Colt Gray, is making his initial court appearance. His name is Colin Gray, and he was arrested late last night, facing charges of involuntary manslaughter and second-degree murder, as well as cruelty to children. He reportedly gave his son Colt the semi-automatic rifle that was said to be used to carry out that massacre. Let's go into the courtroom together now.
Good morning, sir. Are you Mr. Colin Gray? Am I pronouncing your first name correctly? Mr. Gray, my name is Curry Mingledorf. I'm assigned to preside over this morning's proceeding. This is your first appearance hearing. And at this hearing, I'm first going to ask you just a few questions, and then I'm going to advise you of your rights and also let you know about a preliminary hearing that's been scheduled for you. Why don't you just state your name, please? All right, pull the microphone down, please. There you go. All right, and how old are you, Mr. Gray?
54.
And are you able to read and write and understand the English language without any difficulty?
Yes, sir.
How far did you go in school?
11th grade GED.
Okay. And I note that you have counsel seated with you at the table. You understand that you have the right to be represented by an attorney at all times for this and all future proceedings in your case?
Yes, sir.
And you understand that, of course, if you cannot afford an attorney, that the public defender will be appointed to represent you upon your request?
Yes, sir.
All right. And counsel, would you identify yourself, please, for the record?
Donna Seagraves. We are going to have new counsel assigned to Mr. Gray later today.
All right, thank you. All right. Okay, sorry. Just need to make sure that the system is working. And all right, so the following aren't questions that I'm going to ask. I'm just informing you of some things. You have the right to remain silent. Anything you say can be used against you at further hearings or at a trial on the charges that you're facing. For this hearing, you're not going to be questioned about facts and circumstances surrounding your charges. You are currently charged with, and you'll be provided with copies of the warrants if you don't already have them. You're currently charged with 2 counts of felony murder in the second degree. You're charged with 4 counts of involuntary. You're charged with felony cruelty to children in the second degree. Now, for these offenses, for the felony murder counts in the second degree, felony murder in the second degree, the maximum penalty for each count is up to 30 years imprisonment. For felony involuntary manslaughter, of course, again, there are 4 counts. The maximum penalty for each of those offenses is 10 years imprisonment. For the 8 felony cruelty to children counts, the maximum penalty under the law for each of those 8 counts is 10 years imprisonment, for a maximum total possible penalty for the charges that you currently are facing of 180 years imprisonment. If you have questions about these charges, which I assume that you will, the court urges you to discuss those with your attorney. Let me inquire as to whether there's a motion for bond if Mr. Gray is moving for bond at this time.
No, sir, not at this time. We will allow alternate counsel to make that decision.
All right, thank you. I also need to inform you that you have the right to an indictment by a grand jury, and you also have the right to a preliminary hearing unless you make bond or waive such a hearing. You have the right to a speedy and public trial by a judge or jury. You have the right to confront and cross-examine all witnesses. You have the right to call witnesses on your own behalf and testify in your own defense if you so choose. I want to make it clear to you, Mr. Gray, that you are presumed innocent. Your refusal to testify at any point cannot be used against you in determining whether you are guilty or not guilty. I mentioned the first appearance hearing a moment ago. That is being set for you for December 4th, 2024 at 8:30 a.m. Currently that's set to take place in the Magistrate Court of Barrow County. It could be subject to change, but I just want you to know that that is the date that we currently have. In fact, counsel, could you approach, please? I have this, let's see, I need to scratch this out.
Okay, and the signal is freezing up a little bit there. Something totally out of our control, but we're going to continue watching it. So we've got Colin Gray, 54 years old, the father of the Georgia school shooting suspect, Colt Gray, said by authorities to have known the dangers with his son and yet still provided him with a semi-automatic rifle that they say was used to carry out that massacre in which 4 people were killed, 9 others injured. Here are the 4 deceased victims, 2 students and 2 school teachers. Now, this hearing is what's called an arraignment. This is the first arraignment that any criminal defendant will have after their arrest. So this is a quick appearance where you hear they're advised of their rights. The judge asks them if they can read, write, understand the English language, understand the charges against them. The judge informs them of the charges, what they are, and then asks their position on bond. And in both of these cases, neither one of them has requested a bond. I would say that's a very smart move. We're going to get back into the courtroom in just a moment. Stay with us. We continue our breaking news coverage this morning. I'm your host, Julie Grant. Thank you for watching Court TV Live. We're witnessing history this morning. Let's let this sink in, because we have another parent being accused of criminal liability in the actions of their child in a school massacre. We saw this first in Michigan, and we watched 2 trials playing out for James and Jennifer Crumbley because of the actions of their son, Ethan Crumbley, in the murders he carried out at Oxford High School. Now, today, we're seeing even more history as that landmark case in Michigan has now paved the legal road to have more cases like it. And now, sadly, here we are with an eerily similar prosecution of a parent providing their dangerous child with a firearm, even when they are said to have known the dangers. That is the allegation for Colin Gray, who is the father of Colt Gray, the Appalachia High School shooting suspect. The kid just transferred to the school 2 weeks before this incident, where he is said to have murdered 4 people and seriously wounded 9 others. Thank goodness those 9 others are going to make a full recovery per the local sheriff. And this morning, these 2 are both being arraigned in criminal court. Colt was arraigned at 8:30. He's being tried as an adult per Georgia law. And now it's Dad's turn. We had a little bit of an interference with the signal moments ago. It's repaired. Let's return to the courtroom now.
This document discusses bond and gives the date of the preliminary hearing, and I guess I could sign that, and then he could just get a copy of it. And then the warrants are attached to that. Sign that. So, and I would like for him to sign it. Turn it over, please.
Sign right there, just saying you're getting a copy of this. He is giving you a copy. He's going to give you a copy of all the warrants. Do you want me to give him his copy? And the page continues. And are these his copies of the warrants?
Those are provided, and they say service copies on them, so I assume that they're for him.
Okay.
Sergeant Briscoe, do you concur with that? Is that what those copies are for?
That's for the detention center.
Those are for the detention center? So he's got his own copies, or he'll have them provided? All right, so the detention center wants to hold on to those. All right, let me, and thank you, Ms. Graves. I want to certainly acknowledge the presence of our district attorney, Mr. Brad Smith. He's assisted by his chief assistant, Patricia Brooks. Is there anything else, counsel, that the court needs to address that I have neglected to address?
No, Your Honor.
No, sir, not at this time.
All right. I do want to thank those who are in the gallery who have an interest and who have appeared. I appreciate the decorum that has been maintained throughout this proceeding, or both of these proceedings today. And with that, this matter is adjourned.
The attorney who's going to represent you, I think his name is James Rogers. We're going to have the official later today. But he'll come and see you probably the first part of next week.
Okay.
Colin Gray appears to have been crying in his arraignment for the crimes that prosecutors say he is liable for, even though they were carried out by his son per the allegation from law enforcement. This is history we're witnessing this morning in the state of Georgia, as we're seeing now for the second time in the United States of America, a parent being criminally charged as part of a school massacre carried out by their child. Very serious allegations, and the judge noted the decorum that was maintained throughout these proceedings this morning, and that is a packed gallery of people. There we see the local sheriff. He has the glasses on top of his head. He announced last night at the press conference that he was so pleased to say that all 9 of the survivors are going to make full recoveries. How wonderful is that? All 9 of them will be out of the hospital hopefully soon. Some already are, he said, but some are still in the hospital recovering from this horrific incident said to have been carried out by 14-year-old Colt Gray. And his father, 54-year-old Colin Gray, has now become his co-defendant. Again, this is history. It was something that followed the case that people all around the world watched when James and Jennifer Crumbley were indicted, prosecuted, and sent to prison. Every parent in America got a learning lesson that they could potentially be held liable for the actions of their child if they enable their child's dangerous actions. And here, while details are limited, we still have not seen the full affidavit of probable cause, providing all of the information that law enforcement knows. We know enough from that charging conference that officers felt confident in charging Dad with murder and with involuntary manslaughter. Let's talk about this case and all of the facets of it that we know so far. I want to bring back in trial attorney Kelly Hyman here in the studio with me, and Jason Piccolo, retired special agent with the Department of Homeland Security. He's also an author, a firearms expert, and a trainer. He trains the Capitol Police in Washington, D.C. on firearm use. Let's start, if we can, by the differences in Dad's body language and Son's. We saw Son in there, and Kelly, I'm going to go to you on this. As we were watching, the Son looked like he could care less. You were on opening statements with me, and the Son was, you know, he just kind of shook his head and sat there. We didn't notice anything. Dad, we saw some self-soothing behavior with the rocking, the crying, hanging his head. Big difference, wasn't it?
Night and day. So let's talk about the father. As soon as the father walked in, you could see from his body language, he was hunched over. He looked confused on where to go, what to do, where to sit. He sat down. He was, as you said, going back and forth, and got very, very emotional. On the other side, the son, we didn't see his whole face, but just sat there. It appeared was very calm, very cool, very collective. You would very mature, so to speak, for someone his age, with these serious allegations in charge, and answered the judge's question. It was completely different, like 2 different people.
Right. You're right, Kelly. Night and day. It really was. We've got the split screen there. If you missed it earlier, as Kelly noted, we didn't see much of the kid's face. That hair was covering up most of it. And then Dad with a much shorter haircut. You can see the rocking there. Look at him. He rocking in his chair, which we've learned from our body language expert guests. That is a way that defendants kind of soothe themselves sometimes when they're in the hot seat. And boy, oh boy, is he in a hot seat. The allegation that he provided his son with a weapon after both the FBI and the local sheriff's department had investigated his son for making online school shooting threats. 2 investigations. Dad was aware of both and gave the child what is called in the charging documents that we just got a hold of. So I'm referring from the exact document. And let me, an AR, let's see. Oh, I lost my notes. Darn it. Let me pull it up here. Because I want to make sure. Okay, let me look at my computer. A semi-automatic AR-15 style rifle. semi-automatic AR-15 style rifle. Dr. Jason Piccolo, you're an expert in firearms. I know you haven't seen this, but I'm reading the language exactly from the charging document we just got. Tell us about that weapon, please.
Well, it's a semi-automatic weapon. It fires most likely a 5.56 or a .223 caliber round, which is bigger than a .22, a lot more velocity, and it kills. The other thing, AR actually stands for armor light. It's not assault rifle. That's a big misconception about that. But yes, it is one of the most popular firearms out there right now, the AR platform.
Dr. Jason, and thank you for that. That's a pet peeve of mine, and it's a common misconception, you're right, in America. AR, when you see that, that does not mean assault rifle, as Dr. Jason noted. Armalite, the company that developed the AR-15, and now many other gun manufacturers have created similar semi-automatic rifles, have they not? And that when you see something like this language that says AR-15 style rifle, it notes the similarities, but AR does not mean assault rifle. Dr. Jason, still, this is a very, very dangerous weapon for a dangerous person to have. And the allegation here is that this kid was dangerous, that this kid was a menace, apparently investigated by 2 different agencies, as you heard me say, the FBI and the Sheriff's Department, 2 investigations into him making online school threats. And his father is said to have provided him with the gun. What is your response to that?
You know, the FBI, you know, I could have a lot to say about them when it comes to these types of investigations. Maybe they are spread way too thin to do this. But when the father is talked to by law enforcement and the FBI and doesn't take action as a responsible father and allegedly supposed to be a responsible gun owner, he should have taken action. Secure the weapons. Take that weapon away. You are the responsible adult, and that's where these cases come in. Now, one thing I do want to say is maybe if the FBI is spread too thin, maybe we need to have more resources for these schools. You know, we spent $1 trillion+ probably on the TSA to secure airports. Maybe it's time that we secured schools in the same function.
Yes, yes. Preach, Dr. Jason. You know, thank goodness for those 2 school resource officers, those 2 unsung heroes, the good guys with the guns who stopped the bad kid with the gun by approaching him, and when he saw the threat, you know, presumably of the deadly force, then gave up and surrendered. But who knows how many more lives would be lost. Kelly Hyman, let's talk about this. Going on the offensive, we started the conversation earlier, as Dr. Jason was saying, airports, what a great comparison, how we're running things more closely. Your thoughts on some changes that could perhaps be effective in preventing these massacres?
Knowledge is key, so it's really important. As we talked about earlier, the knowledge, if there's some kind of issue with the child, that is, when he goes to a different school, that knowledge is passed on to the other school. So systems in place in the school. I have family members that are teachers, so hearing stories like this is near and dear to my heart, and making sure that not only our children, but our teachers that pass on their knowledge, that dedicate themselves to helping children grow and nourish, that they are safe and protected as well. So that knowledge is key, and absolutely resources to make sure that this doesn't happen again. Enough is enough. I mean, we need to make sure that our kids are safe, they go to school to learn, not worried about someone is gonna come and harm them and they need to hide.
Right, Kelly. I want to see our federal government start spending money in our local school districts. Enough is enough. More of the good guys with the guns, more metal detectors, no more backpacks. Enough is enough. Clear bags. We don't want another Ethan Crumbley situation where we don't feel comfortable in searching that bag. We need more visits from our canine friends. So many things need to be done. We're going to continue the conversation in just a moment, but we've got the first court appearances, the arraignments for the 2 Grays, Colt Gray and Colin Gray, the son and the father now facing charges in connection with the Appalachia school shooting. Our hearts go out to the victims and their family members. And we're learning that there's going to be a press conference soon, and I hope we get some more answers, because it doesn't make a lot of sense to me that dad is only charged with 2 counts of murder. Son's charged with 4, and we know son's accused of killing 4 people. And Dad's being charged with 4 counts of involuntary manslaughter. And so I'm wondering, are we going to see some amendments done? It's not too late. The indictment can be amended for quite some time in this process. So I'm curious if that question may be answered, perhaps by the DA. We're not sure who's going to be assembling, but our team is there in the courtroom. Our producer, Tiffany, noting that Colin Gray was very tearful when he appeared in court to face charges connected to his son's alleged actions.
Go ahead, hit me. Bam.
2 celebrities reveal their turbulent relationship to the world.
He was just Hollywood's mega hunk.
The man who beat me up for 5 years.
The general public sees this, and all they see is wife beater. 2 completely different versions of what was happening. That means one thing: somebody's lying.
Victim to Verdict with Ted Rollins. New season premieres Sunday night, 8/7 Central.
Only on Court TV.
We're standing by and waiting for that press conference to begin in Georgia. We're discussing the cases of Colt Gray and his father, Colin Gray, both criminally charged in connection to the Appalachia High School shooting. I want to bring back in my guests in the studio with me, attorney Kelly Hyman, and standing by remotely, Dr. Jason Piccolo. In the break, Dr. Jason, you were saying something else. Mental health resources are needed as well. Would you expound upon that, please?
I mentioned before with the TSA, we put billions of dollars into the TSA. Maybe we should start looking at different ways to harden our facilities. And that includes mental health resources for children and for teens who are going through struggles, that if we identify someone that may possibly be an active shooter or potential violent offender, that they have mental health resources available to them. Let teachers teach.
Yes, you're exactly right. I didn't mean to step on you there, Dr. Jason. Kelly, to that point, we know the child, his parents were divorcing. It sounds like he was experiencing some trouble with that. Your thoughts on Dr. Jason's comments?
That is really important for make sure that children get the resources they need. Going through a lot of stuff. We know during the pandemic, a lot of children were dealing with all kinds of issues, not being with their friends and being isolated and stuff like that. And those have long-lasting effects. We also have to think about counseling for these victims as well, these children as well, of living through that. But the resources need to be available to the children, and that's really important.
Right. Yeah, most definitely. Because we've got a mental health problem in this country. We do. We've got a mental health problem going on in these cases. We always see that as a component. We always do. And now here we are. We're going to wait for more official word on this case from authorities. We're getting close to the top of the hour. Here's what we're going to do. We're going to squeeze in a break. When we come back, we're going to return to Georgia. You're going to see this press conference going on. Perhaps we're going to get more insight into Dad's alleged conduct. This is a live look outside the courthouse where Dad, Colin Gray, and son, Colt Gray, were arraigned just a short time ago. And as we're thinking about these court cases, certainly, what we're thinking about the most are these 4 people who lost their lives. These 2 students and these 2 teachers, all of them beloved, all of them will always be missed. Thanks for being with us here on Court TV Live. I'm your host, Julie Grant. It has been a really tough Friday morning for everyone affected by the Georgia high school shooting at Appalachia High School. And we saw a packed courtroom moments ago. No outbursts whatsoever, just a very somber courtroom, as 2 defendants made their way before a judge for the first time to be arraigned. Colt Gray and his father, Colin Gray, both criminally charged in connection to that shooting that left 4 people dead and 9 others seriously wounded. We're told that a press conference is set to happen any moment now at the courthouse. Our cameras are positioned there. This is a live picture where you're seeing some of the sheriff's deputies outside. We're going to wait until that begins, and when it does, we're going to go in there live together. In the meantime, there's another hearing that's happening in Florida ahead of the trial for Donna Adelson. This is a pretrial hearing where some outstanding motions are being decided, motions that dictate what evidence comes in, what evidence stays out. Her trial is set for September 17th. She's accused of being part of the murder-for-hire plot that led to the death of her former son-in-law, Danny Markell. Let's go back into the courtroom together now.
Allowed to question Sergeant Corbett. He is allowed to be a witness based on what he did. Our argument is, number one, he's not an expert, and number two, the actual exhibit is not an appropriate summary exhibit that would go back to the jury during deliberations. That's what our memo is about, and it's supported, Judge, by Florida law. So the Florida Supreme Court has held that law enforcement testimony, which merely summarizes and explains data from cell detail records, including the mapping of cell phone location data, is not expert opinion under Florida Statute 90.702 and Daubert, because it involves no scientific, technical, or other specialized skill. Cites King v. State 260 SO 3D 985, Florida 2018. McMillan v. State 214 SO 3D 1274, Florida 217. The Florida Supreme Court has supported that, and also has the 11th Circuit in Batista, B-A-T-I-S-T-A, in affirming the Florida Supreme Court, where the 11th Circuit of Court of Appeals affirmed a district court's decision to admit as lay testimony an FBI agent's use of cell phone records, along with the phone company's records of where their cell phone towers were located, to plot on a map which towers connected with which cell phones at a particular point in time. But it said it wasn't expert opinion. It said that you don't need the agent doesn't have any expertise to read the cell phone records to determine which cell tower was used at a particular time, look up the latitude and longitude of that cell tower in the company's records, and mark the intersection of the latitude and longitude on a map. That's precisely what Sergeant Corbett is doing here. It is exactly on point to what he's doing here. Also, the fact that he pulled data off of iClouds and he pulled data off of iPhones, it's not expert. Now, of course, he's able to testify to it, but it doesn't meet the standards of expert testimony. Now, moving to the second point, Judge, which is whether...
Before you move on after that, when it comes to the data pulls, because I've heard this argued, not by you, but a number of ways over the years. The first being the data pull itself is a factual issue, which I would agree. How the machine works and whether or not the data pull was in fact, it took place technically in a correct manner, that goes to more specialized information. Is there going to be any contesting of any way that the data pull was somehow not technically proper or sufficient? Because if so, at that point, now we are veering into a matter that deals with specialized information, knowledge, or expertise.
Judge, may I have one moment, please?
Go ahead.
You've stipulated to that. That's one of the things you stipulated to. All right, so we'll have to figure that out. Okay.
We're on the same page. Judge, I don't believe it's going to be an issue. But we understand what you're talking about. If it were to become an issue, then obviously the expertise on that particular issue would be obviously subject to his qualifications, which we think he has. Okay, but at this point, we don't anticipate it being an issue. We don't anticipate. There may be questions as to why he pulled it as opposed to someone else pulling it. But as far as whether it was pulled appropriately or not, we're not contesting that.
Very well. You may continue.
Okay, so Judge, if I may just move on to the second part of the argument. The second part of the argument is not dependent on the first. So whether he's an expert or not an expert, it really is an independent inquiry, the second part of the argument, which is whether ultimately whatever turns into his exhibit, his demonstrative, goes back to the jury. And again, for purposes of today, unless you want to go into it, I'm not going to be talking about specific pages that we don't believe are admissible. So let's just talk about the thing as a whole, if that's okay with the court. So, Judge, this summary, and I think you've had an opportunity to view it. It's not, the first thing to understand is it's not a neutral summary. That's the first thing to understand. The second thing to, not that alone does not end the inquiry. It's just a fact.
Well, to that, and obviously a criminal case is different from a civil case, but all the time, in civilly litigated matters, parties will have presentations, reports, summaries prepared. The plaintiff, by nature, is adverse to the defendant. Anything that they're preparing for the jurors is going to advocate or in some way demonstrate why I should win. As it relates to this summary, the state is preparing this in anticipation of litigation to advocate their position. Why is this inappropriate?
That alone, that fact that it's not neutral, is not the determining factor. But it's one that courts would tell you to look at in deciding whether it is a summary that's appropriate to go back to the jury, or whether it is more in line with a closing argument, which would not be appropriate to go back to the jury. So I start with that just because it's just as a basic factual point. I don't think it's determinative of your decision. What is determinative of your decision, though, is when you look at this summary, it's full of items. Again, we're not disputing that the items are admissible. Let me be clear on that. So the summary has, for instance, I think at last count, 30 to 40 emails. Those 30 to 40 emails, provided they survive evidentiary challenges, are admissible. But a summary is done for the purpose of taking voluminous records and synthesizing them in a way that helps the jury. That's what the statute talks about, right? And that's what the case law talks about. That's what Oloyede talks about, which is 933 F3rd 302 310 4th Circuit 2019, where it talks about how we don't send closing arguments back to the jury. That is not admissible under law, because summaries are elevated under Rule 1006 and also Florida Statute 90.956 to the position of evidence. Care must be taken to omit argumentative matter in their preparation, lest the jury believe that such matter is itself evidence of the assertion it makes. So in this document, you see a bunch of items that are not voluminous. They're one page. Rental car agreements. There's no summary needed for that. 2-page emails, 1-page emails. There's no long emails. 1-page text messages. Not necessary. And then you see call records, and you see some call summaries. Again, not voluminous materials. I wish they were, but they were limited in what the call materials were. So, Judge, our argument is that the exhibit itself can be shown. We're not arguing that it can't be shown to the jury.
As a demonstrative, but not as admitted evidence.
Admitted evidence. The underlying evidence in it that's admissible can be admitted, obviously. Now, within the summary, and I think this may be better taken up at trial or in another day, unless you want to take it up now, within the exhibit, we
as to any pages that are specifically disputed as inadmissible, it's best to handle this outside of the presence of the jury, so that way it's clear what is in and what is out when all of it is ruled on.
Yeah, so I mean, we can do that at your convenience. Look, the state has still been updating it, so things may change, but we already see some pages that are either hearsay or privileged under the joint defense privilege, for instance. We already see, there's not a lot, but we already see some pages that we think are problematic, and we can take that up whenever you want. But our argument today summarizes on his characterization as an expert, and either way on the document actually going back to the jury.
Let's handle that part of it then next Thursday. There are still disputes as to individual pages, so that way it can be handled and ruled upon.
Okay, thank you, Your Honor. If you don't have any questions, we'll rest on our papers.
Very well. State, you may respond.
All right, we've got a pretrial hearing, which is going to dictate what comes in, what stays out when Mama Donna's trial kicks off on September 17th. That is the date when jury selection is set to begin, depending on how fast they get it picked. Could be the starting day, could be the next day. What will we see when this case goes? And will there ever be any other Adelsons charged? You know, that's one question that's really still outstanding. Is Wendy ever going to be charged? What about Harvey? Let's talk about it. I've got two great guests standing by, still with me. Retired Department of Homeland Security Special Agent. He's also a trainer with the Capitol Police, a firearms expert, and an author, Dr. Jason Piccolo. And I want to welcome in retired lieutenant, also a commanding officer of the Nassau County Police K-9 unit and the owner of Houndstown, USA, Mike Gold. All right, let's talk about Wendy, and then let's talk about Harvey. So let's start with Wendy first. Lot of inquiring minds wanting to know whether Wendy's ever going to face any charges. Joel Waldman, a friend of Court TV, came on the show earlier and said he's heard from some sources that Wendy is being surveilled right now and that she lives in Austin, Texas. Dr. Jason, your thoughts on Miss Wendy?
If there's evidence to charge her with, they're going to do it. So that's what they're doing surveillance for. They're going to be trying to look for anything to put charges on her.
Mm-hmm. Are you surprised that she hasn't been charged yet, Dr. Jason?
You know, I think erring on a side of caution, they want as much evidence as possible before they place a charge on her.
I mean, you know, depending on what office you're in, you know, different district attorneys' offices think differently. You know, perhaps some may have charged her by now. I keep waiting. I've been on Wendy watch for a long time. Lieutenant Gould, talk to me here. Do you think we're going to see Wendy charged?
Yeah, Julie, so for full disclosure, I have the attention span of an inchworm. So when these cases have all these moving parts and it's 10 years old, there's so many characters, it reminds me kind of the Karen Reed trial. I start to break down, you know, so I'm having, frankly, a hard time following this. I think that, as I said, there's so many tentacles out there that the defense is presenting, and each one of them has some level of reasonable doubt. Or I shouldn't say reasonable, but doubt. There's certainly a ton of incriminating evidence, but sometimes I look at it from the eyes of the jurors, just from my own lived experience. Last year, I went on a trip to Southeast Asia. I bought a one-way ticket. I had my passport, I had my visa. So I don't think that is like, wow, that's the smoking gun. I'm sure there's other evidence, but I didn't check extradition. I just went, and then I decided when I wanted to come back, and I booked a flight back. So it's all of these things as evidence with the son passed. They don't have the record. So there's these little seeds of reasonable doubt. And I think the defense, it's hard for me to follow, and I think the jurors are going to have a hard time, and if they get one person to, I don't know. I have some doubt, not reasonable doubt. Like I said, there's overwhelming incriminating evidence, but it's hard for me to follow, Julie.
Sure. Yeah, it is. And, you know, and acknowledging that, Lieutenant, fair point taken. At Court TV, when we relaunched the network in 2019, this was one of the first cases that came up, and it was with the gangbangers. It was with Sigfredo Garcia and Luis Rivera, and we're hearing about Catherine McBanawa. You know, she was part of this too, and the, you know, girlfriend of one of them, and also we heard how she dated this rich doctor. And all through the trial, we all were saying, you know, we're hearing a lot about these Adelsons. Why aren't these Adelsons here? And it just, this case has moved at a snail's pace. It really has. They went for the low-hanging fruit first, the gangbangers, worked their way up to girlfriend of gangbanger, then worked their way up to, you know, same woman, girlfriend of rich dentist, and now we're with dentist's mom. That's the next trial. And I just think in all of this, to really cut through the facts, the person that stood to benefit the most from Danny Markel's murder was Wendy. Arguably, it was Wendy. She's the wife. She was losing. They were in a bitter custody battle, and he was winning the battle in court. He just got a big ruling in family court where he was winning. The kids were going to stay with him, and she was presumably not happy about that. You know, and when you think about who did this stand to benefit, it wasn't Charlie. Maybe Donna, yes, because she would get to see her grandkids more, but really Wendy the most. Dr. Jason, doesn't that count for anything?
It does, but the thing is, if they don't have enough to charge her or convict her, they're most likely not going to take her to trial. So maybe they'll wait for to try to flip someone somewhere and come up with some evidence, but they're not going to do it until they have a solid case.
Yeah, they did. We saw as part of the evidence, Lieutenant Go, do you like this? They called it the bump, you know, where an undercover law enforcement officer kind of let Donna know, you know, that there would need to be a payoff for what happened. And that got Donna talking. Do you think we may see another one of those? Although Wendy's, you know, probably very suspicious of anything now. But your thoughts, if she is being surveilled, Mike, do you think they may be trying to do something like that with her?
Well, as Dr. Jason said, you know, they have to come up with the probable cause to make an arrest, reasonable cause. You know, so with all this circumstantial evidence, like I said, it's like an octopus, tentacles of circumstantial evidence all over the place. You know, so many times in life and circumstantial evidence, things can be very mysterious and coincidental, but they're not always illegal. So I think there's, for me, just my takeaway of listening to the defense and the prosecution and their different theories of the case, it's complicated, and it's actually, it's 10 years out, they're surveilling people. I don't know why they haven't made, you know, frankly, got to the bottom of it a little earlier, but of course, cases go on and on and on. This is one of them.
Right. And I know there are some DAs out there who I'm sure would have filed some charges by now, especially on Wendy. You know, Harvey, he's a little more questionable. But we'll continue the discussion. We'll see if they get enough evidence, as you both noted, for charging. Stand by kindly, please. We're going to hit a break. When we come back, we're going to continue monitoring Mama Donna's final pretrial hearing. Stay with us.
Did you know that in middle-income communities, there are about 13 books for every child?
But in some underserved communities,
there's only one book for every 300 children.
Studies show that having lots of books at home is one of the best ways to help a child succeed in school and beyond.
That's why the Scripps Howard Fund started the If You Give a Child a Book campaign
to give books to children who need them most, like me.
So please, if you could give a child a book today.
Just scan the QR code. We would be so grateful.
Hey.
Back to court we go. We're in Florida watching a pretrial hearing from Mama Donna Adelson, getting ready for her homicide trial to begin on September 17th. Let's go in together and watch some more now.
Morning, Judge.
Good morning.
So the defense motion argues that, you don't have to be an expert in order to testify to phone evidence, and they cited the King and Gordon cases in their motion and talked about them this morning. I think it's important to consider that in both of those cases, which were post-conviction motions, where the court said that the defense was actually not ineffective for not getting their own expert or not objecting to the witness testifying for not being an expert. The defense did not object to a non-expert law enforcement officer testifying to the cell phone evidence in that case because it was a strategic decision. The defense knew that they could cross the law enforcement officer more effectively than an expert, and the state could easily get someone more qualified had the defense objected. In Gordon, the court said that the witness from the phone company who testified would have qualified as an expert to testify to that data and been able to testify to the cell site data had there been an objection. In King, in that post-conviction evidentiary hearing, the defense put an expert on the stand who provided expert testimony on GPS and on cell phone location data. The defense expert concluded that the defendant could have been at home, not at the crime scene at the time of the murder. So in that case, there was an expert who testified to the location information from the cell phone records.
That does lead me to my first question concerning Sergeant Corbett. What exactly is he going to testify to beyond what the cell phone data history records or cell phone tower records would show? That otherwise you need him to testify through an opinion that he cannot just testify off the records themselves.
Yes, sir. So he's going to be, and I have this in just a second, but as far as the summary goes, he's not testifying as an expert to everything in the summary, but he's testifying as an expert to a large part of the summary when it comes to cell site location data and how far, who's using a handset at the time and how far the person is from the cell site location. He uses, though, more...
So you're saying how to interpret that data?
Yes, sir. And he uses more than just cell phone records to do that. But the cases, the Gordon and the King cases, those cases say a witness does not have to be an expert to testify to some of that information. But they're not saying that you cannot present an expert to offer an opinion on a handset's location if that witness has the necessary training and experience, just as was done at the hearing in the King case and could have been done at the trial at the Gordon case. And Sergeant Corbett has hundreds of hours of training and experience and has offered an expert opinion well over 100 times in circuit court. The reason they don't want him to be able to declare an expert, they don't want him to be able to offer an opinion. And this is more than just a data pull of, hey, we got these cell phone records. And this is more than just, this is where the cell site locations are at any given place in Florida. This is him forming an opinion on how far a handset is from a location, who may be using the handset at the time that you need this specialized, or that it's beneficial for the jury to hear his specialized knowledge because he's able to interpret the cell phone records to tell us that information. The defense also argues in their motion that there's basically just too much evidence in this summary, that it's more than just for phone records and some of the evidence isn't voluminous. But a summary's whole purpose is to summarize relevant evidence. Sergeant Corbett, as I said, is not offering an expert opinion on everything in the summary. He's offering an expert opinion on the interpretation of the cell phone records, the location of the handsets, who may be using the handset at the time. And there's a large part of the presentation that are those things, but there's a lot more information in the summary, like surveillance video from Premier Gym, a traffic ticket received by the suspect, a car rental agreement, that maybe those things individually aren't voluminous, but they're all material to the presentation and material to his opinions because he's using them to provide an opinion on who had the handset and where the handset was at the time. For example, if a certain suspect's phone is communicating with a cell site that's consistent with like a car rental company, an expert may be able to better determine who was using the handset at the time and confirm their actual location and confirm the reliability of the cell site information. If we're able to see that, well, that person actually got a rental agreement at the time, they got a traffic ticket shortly after the car was rented, all of those things help him form his opinions and determine that. The defense says, this is a closing argument. The information that he looked at in this case, there is so much digital evidence that it is very all-encompassing. However, there's not, what's in the presentation is not, it's all data. It's messages, it's emails, it's different business records and cell phone records that we received that helped him form those opinions. They talked about the 30 or 40 emails. When I'm handing them over the things that I may use in my presentation, I'm trying to be as thorough as possible. I don't want them to have less information than I may use. I don't intend to use all 30 or 40 emails. I don't intend to have Sergeant Corbett sit up there and read all of those, but I wanted to send them all of the ones that I may use as far as just, these are what was found in these different accounts. This was and asking him, hey, did law enforcement find some evidence of motive that caused him to look into these people? Yes, X, Y, and Z were found. Maybe spend 3 minutes to 5 minutes on that and move on to the next thing.
As to that point, and I believe the defense's motion hits on this as well, for what you have asked Sergeant Corbett to add to this, is that in fact his opinion?
So the defense motion attacks that, the prosecutor is ultimately deciding what's going into the presentation. Maybe that's what you're referring to.
Yes.
But Sergeant Corbett's job is to pull information from these devices, interpret that data from the cell phone records. He's not investigating or prosecuting the case. In the investigative phase, he has to rely on the investigator to let him know what he's looking for, what this proverbial needle in the haystack is, whether he's wondering it exists. And Sergeant Corbett's then looking through the records to see if there is one, and then if there is one, including it and letting them know. Sergeant Corbett doesn't know exactly what the prosecution wants to present at trial. I talk to him about what the records show. I ask questions. He looks for answers. He lets me know what the data says. And then I'll say, yeah, can you put that in there? I think that that's important. He's not the one talking to witnesses. I may talk to a witness. They tell me a certain event occurred. Then I go back to Sergeant Corbett and say, hey, is there any evidence of X happening? And he lets me know that. That may corroborate what the witness says, and then we're able to put it in there. And I'm not able to get that information in any other way because he's the person that's looking in these cell phone records and can let us know whether that evidence is corroborated or not, and can provide an opinion on whether what the data shows, where that handset was at the time, where that, how far they were from the tower at the time, things that may corroborate witness testimony or appear in the cell phone records that I wouldn't be able to see or know on my own. The defense motion also argues that the summary isn't admissible, but summaries are admissible. That's the whole point in using them, and there's no case law that I know of that says otherwise, that a summary isn't admissible and has to only be used as a demonstrative, and the defense doesn't cite any either. The defense has specific objections to certain slides because of hearsay or privilege or other things, which I'm ready to discuss at any time the court is. But as far as the summary not being admissible, there's no case law that I know of as to that. And the defense hasn't cited any either. That's all I have.
Very well. One question about the document itself. And I think this is really what goes to the heart of the defense's motion about the summary. If you're taking, say, thousands of pages of documents and you reduce them to, let's give it an arbitrary number, a 25-page report, you have synthesized the larger to the smaller into something that is digestible for the jury to use in making their decision. That, or at least in quoting their position, is not argumentative. Some of these things are more or less a part of the state's summary, at least as it stands right now. It's showing corroboration of other evidence. Is that in fact a summary in the sense that the statute defines a summary?
Yes, sir. I mean, this is the things that may corroborate other evidence, though, help this expert form his opinion. As the example I gave with the traffic ticket and the rental agreement, he's able to, from the phone records, say this phone is consistent with this cell site at the time. They may be this far from there, but as far as showing who has the handset at the time, like who's talking on it, and how far they are.
We're going to hit the pause button here on these arguments. We'll get you back to Florida in a couple of minutes. Thank you for spending part of your Friday morning with us here on Court TV Live. Welcome back to Court TV Live. I'm Julie Grant. We have some breaking news just coming in. Attorneys for the man accused of killing 4 Idaho college students are now seeking to remove the death penalty from his case. Prosecutors have said they intend to seek the death penalty for Brian Kohberger if he is convicted. The defense argues, among other things, that Idaho's system of obtaining death convictions is unconstitutional at this time. There's going to be a hearing on this matter set for November the 7th. Kohberger is accused of murdering Kaylee Gonsalves, Madison Mogan, Xana Kernodle, and Ethan Chapin last November in Moscow, Idaho. Now, let's return to Florida, where Donna Adelson is in court for a pretrial hearing. Let's go back up where we left off.
How far they are from it. It's all of that other evidence that helps him form his opinion.
Very well, thank you. brief response if you have one.
Really brief, Your Honor, and I just want to make this clear, and I think you understand our position perfectly. We're not arguing that summaries are not admissible. We're arguing that this isn't a proper summary. That's the argument. We don't make an argument in our papers that summaries are not admissible. We're saying that this document doesn't meet the foundations of the Florida statute as a proper summary. Again, they're taking particular points, but these are not voluminous documents that they're now summarizing. So there's only one voluminous document that they're summarizing in this entire presentation, and that's how they got originally to Harvey Adelson's phone number, where they had data that would go to the ceiling. If they wanted to do a summary exhibit on that piece, it might be allowed. But everything else is not voluminous materials. It's a closing argument. To allow them to put that document to the jury would essentially be the same as saying, you know what, Ms. Kappelman, Ms. Dugan, when you do your closing, the PowerPoint that you do, that should go back to the jury too. Because it's essentially the same thing, Your Honor. There's no difference. That's all I have, Your Honor.
Well, concerning this motion, I'm prepared to rule on part of it today. As to whether or not Sergeant Corbett can be properly qualified as an expert witness, I will find if Sergeant Corbett is capable of testifying to the interpretation of the records that go beyond just merely where the towers are, what was pinging, and what the phone records show, that would go to scientific or technical expertise in which he is properly able to give an opinion. As to the summary itself, and I do not want to belabor this point, but I do believe I am going to need to hear from Sergeant Corbett specifically as to how he put this together, and his opinion was informed by the information that is in the summary before I can rule on it. Otherwise, I agree with the defense position. This is proper as a demonstrative, but to admit it as evidence, I'm going to need to hear more. We'll have part two then, in which Sergeant Corbett can testify concerning how the summary was created and how his opinions were formed by the evidence that are within the summary after we have the docket sounding next week. As to another matter in which I am prepared to rule on at this point, concerning the defendant's motion in limine, concerning testimony from Wendy Adelson as to the storyline of her book and also changing the names of the children, I will permit the state to use this information for impeachment, depending on what is developed during the examination of Ms. Adelson. As to the other matters concerning her testimony, that has already been ruled upon. Has the state also decided which jailhouse recordings you're intending to use for evidence? Because I did need to review those.
Yes, sir. As of right now, we do not have any jailhouse recordings that we intend to introduce that feature Mr. Adelson, which is what the defense was objecting to. So that's why we have not sent any to Your Honor. May I clarify what you just said about the name changes? You said it could be used for impeachment. May I? She admits that point, or has previously. Would I be permitted to inquire about that area?
As it relates to any prior testimony she's given on the subject, you may inquire as to that.
Thank you.
Very well. I believe still outstanding.
Judge, I'm sorry.
Go ahead.
I just want to make sure I understand now. So our motion was to prevent them from inquiring as to the name changes. So in other words, our motion was Ms. Kappelman or Ms. Dugan can't ask her the question, did you change the kids' names? That was what our motion was. So I'm just not sure the ruling. Can they ask that question?
Well, on that particular point, what is this being offered for, Ms. Kappelman?
For motive, Judge.
As it goes to motive, I will permit it for that reason, or also impeachment, depending on what comes out. Motive and bias are equally available for both parties to explore. All right. As to the state's motion in limine, I believe there was also one other outstanding item to be addressed. Concerning Luis Rivera's gang affiliation, as to this particular point, and I've researched this further, Mr. Rauschbaum, as to the name of the organization, I'm really failing to gather why hearing I was threatened by a gang member versus I was threatened by a Latin King member is going to in some way create a greater credibility in front of the jury for the narrative that you wish to weave. I will permit Ms. Adelson, if she testifies, that she acted in accordance with being threatened by a gang member. The specific name of the gang, I don't believe in any way is going to assist the trier of fact in terms of assessing her story, whether it's credible or not. They will make their determination if they believe this testimony. I believe that was the only other outstanding matter of the state's motion in limine. As to Jeff Lacoste, I have not finished my research yet on that matter, but I will rule on it before we start with any selection of the jury. Do the parties have any other matters that we need to address this morning?
Yes, sir, just a second.
Judge, in contemplation, like a planning when to start evidence, can we all agree that we would not start the presentation of witnesses until Friday, the first Friday?
Assuming that we have the jury selected by Thursday.
Yes, sir.
Well, that would probably be appropriate. Does the defense have a position concerning those?
You have 1 moment, Your Honor.
Go ahead.
That's fine, Your Honor.
Very well. Assuming we have a jury by Thursday afternoon, we would start with the case on Friday. Well, would the parties be able to go to their openings, assuming there's enough time Thursday afternoon?
Yes, sir.
Mr. Rauschbaum? Very well. If we have enough time then, after we have the jury selected and sworn, we would give openings and then launch into the testimony from there with all the witnesses. Does the state have an idea, at least in terms of days, how long you think the case in chief will last?
I think 6 to 7 for our case in chief, Judge.
All right. Does the defense have any idea at this point?
I would say it depends, obviously, but I would think 2 days.
Very well. No one is going to be held fast and firm to this. I'm just asking for an estimate. One other matter to address with the defendant directly before we finish this morning. Ms. Adelson, next week we are going to have your final pretrial. That is typically the hearing in which I inquire of both parties if they are in fact ready to go to trial, if any continuances are necessary, and also information concerning plea offers. As I stated to you in a previous hearing, I do not prod people to take pleas. However, if you wish to consider a plea offer from the state, the time is rapidly coming for you to make that decision as to whether you desire to entertain any plea offer or not. If you want your counsel to provide an offer.
All right, the judge letting her know if you intend to entertain a plea offer, the time to do it would be before trial begins. September 17th, they're going to start picking that jury. You heard the judge, if they have it by Thursday of that week, they'll start on Friday. When we come back, the judge addresses Donna Adelson. We'll take it live next.
Go ahead. Hit me. Bam.
Two celebrities reveal their turbulent relationship to the world.
He was just Hollywood's mega hunk.
The man who beat me up for 5 years.
The general public sees this, and all they see is wife beater. Two completely different versions of what was happening. That means one thing: somebody's lying.
Victim to Verdict with Ted Rollins. New season premieres Sunday night, 8/7 Central.
Only on Court TV.
For staying with us. Let's go back to Florida now. The judge is about to address Donna Adelson. Let's watch.
Offer to the state Also, the time is coming very close to a conclusion for them to do that as well. I'm not going to prod you either way, but I want you to be mindful of the fact, once we begin jury selection and the denial is sworn, that means trial has started. From there, basically, because of count one, if you are convicted as charged, my hands will be tied concerning any sentencing on that matter. Your attorneys will have further discussion with you concerning this, but if you are considering anything at all, you need to make a decision on this quickly. Do you understand where I'm coming from?
Yes, I do.
Very well. We are in recess. I will see everyone next week at 9 o'clock, September 12th. Yes, sir.
Maybe we briefly go sidebar.
Yes.
All right, the judge letting the parties know he's going to see them on September the 12th, and they're going to have a little sidebar here. And that is it for today's pretrial hearing. It's almost the weekend. Mama Donna doesn't have any weekend plans. She's spending the weekend in jail. She has been locked up since she was arrested on the jetway in Miami when she was trying to board that flight to Vietnam. She bought a one-way ticket, and authorities say that she was trying to flee justice. And now prosecutors get to use that as a special instruction to the jury. Flight as consciousness of guilt. Let me tell you, it's a gem when you get to use that instruction as a prosecutor. Big advantage they will have with that. Now, we'll leave Donna's case here for the time being, but as you know, it's one of the major cases that we're following at Court TV. And again, September 17th, it's a Tuesday. That's when they're going to start picking the jury. They expect the trial to begin on the 20th. So you may want to go ahead and mark your calendar. Court TV will be there, and we will broadcast it live for you. Right now, before we go to break, I want to tell you about something that you should include in your weekend plans. Victim to Verdict with Ted Rowlands returns Sunday night, the new season premiere, and we have a little preview for you. So let's take a look of what's coming up.
You know, they say captain goes down with the ship, and if he goes down, we're going with him.
I don't know, it just kind of sucks to see him like have all this downfall from this, and then there's actual evidence that Amber actually was the one that did a lot of it.
You can just see that he's innocent, but like when you look at her, you can kind of see like the evil in her eyes.
I came out to support Amber because there's two sides to every story.
Oh, you know the case that they're going to be featuring? The case of Johnny Depp versus Amber Heard. Ted Rowlands' show, Victim to Verdict, is coming up Sunday night at 8 p.m. Eastern. And coming up after this break, Ted will be here, and we're going to be watching this right here live. The press conference is just getting underway. We're going to play it back from the start next live here on Court TV. This is in Georgia over the Appalachia High School shooting.
Live, I'm Ted Rowlands. Glad to have you along with us on this Friday as we round out another busy week here at Court TV. The top story, of course, at this hour is that Georgia father and his 14-year-old son both appearing in court today on charges related to the deadly high school shooting. Teenager Colt Gray charged with 4 counts of felony murder. He'll be tried as an adult. His father also making a court appearance. He is being charged with felony murder. Right now, we want to head out to the courthouse. There is a press conference taking place. Let's join it now.
Which encompasses Barrow County, Jackson County, and Banks County. This is Patricia Brooks. She's my Chief Assistant District Attorney. We will be handling this case of Colt Gray and Colin Gray. You just had the first appearance hearing, which is standard for people when they're charged with crimes here in Georgia. I am bound by ethics or constrained by ethics not to talk about the facts of the case. But I wanted to answer any questions you may have about the process or the charges. The next step in the process will be grand jury. The grand jury has already been in panel and have been hearing cases. Their next scheduled meeting is going to be October 17th. That is closed to the public, so you will not be able to see that. After that, he will have a scheduled arraignment. I don't have a date for that yet. And then we'll start the trial process at that point. There will be additional charges on Colt Gray. When he was taken into custody on Wednesday, we did not have the identities or the conditions of the other victims, so we were not able to charge on those offenses. So when the evidence comes in and they've been able a chance to heal physically, emotionally, and spiritually, we will get with them, and there will be additional charges that address the other victims in the case. I do not know if there will be charges on Colin Gray. There may be, depending on how the investigation comes forward. But you can anticipate there will be new charges on Colt Gray because we never addressed the other victims in the school. There will be, when those charges come out, another first appearance hearing. Because of that, I would rather not have the charges come out piecemeal. We will probably wait until the investigation is complete and then do it one time. And I do not know when that will be. Many people have been helping with this investigation. I want to thank the Banks County Sheriff's Office. I want to thank the Georgia Bureau of Investigation, the Barrow County School System, and I can't tell you how many people I've met from across the state, from every jurisdiction, that have poured out here to help us deal with what's happening in the tragedy in our county. I want to especially thank Governor Kemp for his resources. He's long been a friend of Barrow County, and I know his heart grieves, and thank him for his services. Do you have any questions? Again, I am bound by ethics not to talk about the facts of the case. Yes, ma'am.
How unprecedented is it to charge a parent in connection to a shooting?
My understanding is this is the second time in the United States and the first time in Georgia.
And do you think that we're going to continue to see this trend of holding parents accountable?
I would hope that prosecutors would use every arsenal or every tool in their arsenal to hold people accountable for crimes that they commit.
Can you tell us anything about his mother?
No, ma'am.
She's cooperating with the investigation as far as you know, but no charges on the horizon for her?
I have not spoken with her, but I believe she is cooperating this time.
So my apologies if this has already been asked, but with Colin Gray, the 2 counts of second-degree murder, is there a reason it's not included?
Yes, ma'am. Second-degree murder is different in Georgia than other states. It's a rather new charge, and it is specifically geared towards cruelty to children in the second degree. If you commit cruelty to children in the second degree that causes a death, that is second-degree murder. And so the 2 children that were killed would be the second-degree murder. It would not apply to the adult decedents.
I'm sorry, I missed the beginning. You said there'll be additional charges for Colt, but no for Colin.
I know there will be additional charges for Colt because we never addressed the other victims. There may be, I cannot say, for Colin until we get the investigation completed.
Sir, just behind you today during the court hearing was a whole line of victims' families. They were quite emotional during some of your presentation. Did you feel the weight and gravity of their emotions today as you were in court?
Absolutely, not just the victims here, but every victim. And you don't have to have been physically injured in this to be a victim. Everyone in this community is a victim. Every child in that school was a victim. As you probably know more than me, that the crimes are continuing around our community with people making threats and doing terrible things. And so, yeah, there's victims all over the place, and I feel the weight of all of that.
Will you be asking for additional help because of this case?
We've been assured by a lot of people that any help we need will be forthcoming.
Excuse me, on the second-degree charges for Colin, those are tougher to prove. Is that in reference to the gun being given to you as a Christmas gift? Is that what you're basing that on?
I can't go into the evidence that we're basing it on, but that will come out in further charging instruments. Involuntary manslaughter is doing the reckless conduct of endangering the health of people by not following a substantial and unjustifiable risk that causes the death. So that was all 4 of the victims were charged with the involuntary manslaughter. The additional charge of the cruelty, the murder in the second was added for the children because that's based on cruelty to children.
Mr. District Attorney?
Yes, sir.
How often does the grand jury meet in Barrow County, and when is the next time the grand jury is going to convene?
The grand jury will be convening on October 17th, is that correct? Yes.
Did the dad have any kind of lock boxes or a way to secure the weapons at the house?
I can't talk about the facts of the case.
Sir, I know that you met with some of the families of the victims
Yes.
after the meeting.
Yes, sir.
Can you describe how that meeting went, what they asked you, what you told them?
I was explaining the criminal justice system. It's a very confusing animal for people, and I was explaining what they can expect to see, what they can expect to happen, resources they can reach out to if they need anything, those sorts of questions.
What sort of questions did they have for you?
Those kind of questions. What's next? What can they expect? Yes, sir.
Sir, with the judge coming back in, taking death off the table for the 14-year-old, how did that discussion play out with the judge?
The judge was simply reading the possible penalties that there exist for felony murder. So that's what he's talking in generalities. He knows nothing about the facts of this case. He's an impartial judge. He's just reading the generalities. And for felony murder, the death penalty is normally one of those. The Supreme Court of the United States a while ago has stated it's unconstitutional for anyone under the age of 18. So after the fact, we told him or reminded him that it was not an option for this case, and so he brought the child back out to tell him that.
Sir, every case is important, undoubtedly, but how would you describe how monumental this is in terms of all the media attention, the eyes, in terms of your point?
We have certainly tried extremely important, extremely difficult. I've been a prosecutor for 28 years. We've tried extremely difficult, extremely emotional. I would say the scope is the largest. This is the attack on an entire community. So I would say that, the scope.
Is there a message to send by
My job is to prosecute people without fear, or affection, and that's what I'm going to do. I'm not trying to send a message. I'm just trying to use the tools in my arsenal to prosecute people for the crimes they commit.
Have you used these particular tools before? Have you charged one of these second-degree murders off of cruelty to children before?
No, I don't believe I have.
Have you been contacted by any political figures above the governor, like senators and presidential candidates, anything like that?
I have not been contacted directly by anyone. No.
Also, can you repeat the timeline again for the court hearing? You said next is going to be the grand jury will convene.
There will be another one of these hearings when the additional charges come. I can't tell you when that will be because I don't know when the charges will come out. The next date I know of is October 17th, which will be grand jury.
And then the arraignment is December 4th?
No, ma'am. The arraignment hasn't been set yet. The December 4th date was a preliminary hearing date that the judge set, and that may change.
Did you look to the Ethan Plumley case in Michigan for guidance on how to approach your case?
No, ma'am. We use Georgia law and the facts we have in our case. Any other questions? Thank you for your time.
Many family members on state now that the death wasn't on the table, especially those who don't really know the law. Did they express any type of emotion regarding that?
Nothing was spoken to the family about it, and they've never spoken to us about it. Any other questions? Thank y'all. Appreciate it.
All right, that was Brad Smith, District Attorney there in Barrow County, Georgia, talking about the process moving forward for both son and father. Colt Gray, 14, Colin Gray, 54, both appearing in court today for their initial appearances. October 17th is when the grand jury will hear this case. After that, it is presumed there will be indictments handed down and the process will move to its next level. Kelly Hyman is with us. She's in studio, trial attorney. This is a case where it might shock some people that didn't maybe follow the Crumbly case up in Michigan. What, the dad's been charged in this school shooting? He didn't do anything? Well, this is a unique case. It's the second one now that we've seen where the parents are being held accountable for something they didn't do. What's your take?
The other case is key in regards to looking at what is going to happen in this case. So when we look at the other case, basically two things that we can see is one, did they make sure that the gun was safe? Did they make sure that the gun was protected? And second, what is their knowledge? In regards to this case, that's definitely going to be key when this case goes to trial, whether what the dad knew, what knowledge did he have? Did he lock up the gun? Did he just have it around the table? Did he, give it to his son? And then also what kind of knowledge he knew of what was going on. As we talked about the FBI, and there were some issues about the son potentially being a shooter.
Yeah, when Colt Gray was 13, he was on the radar of the FBI through, I guess, a gaming council communication where he threatened some sort of school shooting. The authorities show up at the house, interview Dad, interview Colt. Both, he denies it. Dad says he doesn't have access to guns, and now here we are. And apparently he did have access to an AR-type rifle. When you're looking at the grander problem of school shootings, our country has failed miserably at trying to curtail them. Typically, it's a suicidal event that a young person goes out with in a blaze of glory scenario. A couple different things here. It's now we're seeing going after the parents. Prosecutor right there said, I'm not trying to send a message, but he is sending a message. And that message might be a good message at the end of the day in the greater scheme of trying to combat this, because it's a huge line of defense. The parents are the ones that are there. They and have the ability to monitor what the access is, what the behavior of the child is. And having a little fear might be, in the grand scheme of things, a good thing.
Well, everyone's entitled to their gun. It's constitutional, right? They're allowed under the Constitution the right to bear arms. But there also are certain restrictions, and that goes
to... like a 13-year-old.
And making sure that the gun is safe, that it's not just laying around, that there's certain procedures and stuff in place to make sure that it's protected. And so something like this doesn't happen.
And in this case, you literally had a kid that was on the radar of law enforcement. That should have changed the game completely. But to your point, there's nothing they could do. All right, you get this threat from some dumb kid on a gaming console. You're not going to arrest the kid, right? There's nothing to do until something happens, sadly. And we see this with domestic violence cases all the time, where people say they're in fear. Well, there's no. It's such a hard problem to solve, and obviously it hasn't been solved. But the parents being responsible, I think, at the end of the day, and I was totally against the Crumbly prosecution at first. I think there's a little bit of there that there has to be accountability with parents. At the end of the day, I mean, kids are dead because of the actions of their child, and they didn't do anything to stop it in terms of access to the gun, according to the state.
Accountability is going to be key. As we can see from the Crumbly case that happened, and they both were convicted of the case, that's something. And as you point out, they're sending a message, right? Even though there's not, they're sending a message that people need to be held accountable for their actions. And if the parents weren't accountable, if they didn't make sure that this gun was safe, and they had some kind of knowledge, if they knew that this was going to happen, then they had to do something to protect the children and the teachers.
Yeah, absolutely. And the community, to the Brad Smith's point, this was an attack on the entire community there in Barrow County, Georgia. Colt Gray, Colin Gray, both in custody. Both were in a courtroom this morning. You watched it all play out here on Court TV, and we'll continue to monitor this, and we'll have updates throughout the day here on Court TV as this horrible story progresses, not only at Appalachia High School and in this small community, but also now in the court of law. We'll get a break here. Quick programming note on the TikTok murder trial you saw right here on Court TV. Ali Abulaban being sentenced today. He, of course, is that former social media star who was convicted of 2 counts of first-degree murder. He took the stand in his own defense. He was fighting with the prosecutor. He just didn't stop. In fact, he apparently was posting after his conviction and had to be stopped. Will he speak at his sentencing? I bet he does. And he'll also have to listen for maybe the first time in his life during victim impact statements. That's noon Eastern right here on Court TV. Also ahead, Donna Adelson back in court for her final pretrial hearing. We'll look at the rulings made by the judge ahead of her trial right after this. Stay with us.
Go ahead. Hit me. Bam.
2 celebrities reveal their turbulent relationship to the world.
He was just Hollywood's mega hunk.
The man who beat me up for 5 years.
The general public sees this, and all they see is wife beater. 2 completely different versions of what was happening. That means one thing: somebody's lying.
Victim to Verdict with Ted Rollins. New season premieres Sunday night, 8, 7 Central.
Only on Court TV. In the world of true crime, the path from victim to verdict is never a straight line. Join me for a Court TV original series that takes you through every dark twist and turn, from the crime scene to the courtroom in America's most compelling cases.
She killed my daughter, and he marries her.
Victim to Verdict with Ted Rollins, a Court TV original series. New season premieres September 8th.
Only on Court TV. Welcome back to Court TV Live. In the matriarch mastermind murder trial, the defendant appeared in court this morning for the last of the pretrial hearings. Donna Adelson is accused of conspiring to kill her former son-in-law, Dan Markell. Her trial is set to begin September 17th. It's coming. During today's hearing, the judge heard arguments on expert witness testimony and whether or not jail calls between Donna and her son Charlie can be used at trial.
Has the state also decided which jailhouse recordings you're intending to use for evidence? Because I did need to review those.
Yes, sir. As of right now, we do not have any jailhouse recordings that we intend to introduce that feature Mr. Adelson, which is what the defense was objecting to. So that's why we have not sent any to Your Honor. May I clarify what you just said about the name changes? You said it could be used for impeachment. May I? She admits that point, or has previously. Would I be permitted to inquire about that area?
As it relates to any prior testimony she's given on the subject, you may inquire as to that.
Thank you.
We'll discuss what happened today in just a moment. But first, let's get you caught up on the key players in this case. Here is Court TV anchor Julia Janae.
Luis Rivera was the first person to face justice for the murder of Dan Markell. He pleaded guilty to the crime and told police that his longtime friend, Sigfredo Garcia, approached him about a murder-for-hire plot. Rivera, who was a leader of the Latin Kings, told police that he and Garcia drove from Miami to Tallahassee to kill Markell, and that Garcia was the trigger man.
Soon as we were in, Garcia jumped out the car and went around, went to the driver's side. Shot him.
He shot Mr. Markell?
Yes, ma'am.
How many times?
Twice.
As part of Rivera's 2016 plea deal, he was sentenced to 19 years in prison. The second person convicted was Sigfredo Garcia. Garcia's ex-girlfriend, Catherine McBanawa, was dating a Miami dentist, Charlie Adelson, the brother-in-law of victim Dan Markell. In 2013, she was the connection between the hitmen and the Adelson family.
This New Year's Eve in 2013, were you dating Charlie at that time?
Yes, ma'am.
Okay. To your knowledge, did Mr. Garcia know about your relationship with Mr. Adelson?
Yeah.
Okay. Did Mr. Adelson know about your relationship with Mr. Garcia?
Yes.
The state alleged Sigfredo Garcia shot and killed Dan Markell, and that the money trail linked Garcia and Rivera to McBanawa, to Adelson, and his family dental practice. Garcia and McBanawa were tried together in 2019. He was convicted and sentenced to life in prison. Her trial ended in a hung jury. Then in 2022, McBanawa was retried after prosecutors were able to enhance FBI video that showed her and Charlie Adelson talking about the investigation into Dan Markell's death and about how they plan to avoid arrest.
If a badge comes up to you, tell them have a nice day, officer. Listen, if they want to charge you with something, charge me. If not, I don't talk to cops. Sorry.
The La Dolce Vita restaurant video played a key role in the case. McBanawa was the third person to be convicted and was sentenced to life in prison. Charlie Adelson is the fourth person to be convicted in the plot to kill law professor Dan Markell. Adelson testified in his own defense October of 2023 that McBanawa, Garcia, and Rivera were blackmailing him.
They think it was a murder for hire. And
what was it?
It was an extortion.
McBanawa and Rivera testified at trial that Charlie was the mastermind of his ex-brother-in-law's murder. He was sentenced to life in prison. Donna Adelson is the fifth person to face charges for the death of her estranged son-in-law, Dan Markell. She was arrested in November of 2023, a week after her son Charlie was convicted. She and her husband Harvey were boarding a one-way flight to Vietnam, which has no extradition treaty with the U.S.
So, Ms. Adelson, at this time, you're being held with no bond on count one.
She's charged with murder, conspiracy to commit murder, and solicitation to commit murder.
You'd have no contact with the victim's family. You'd have no contact with any co-defendants and no contact with any witnesses that are listed in the probable cause affidavit. Do you understand those conditions?
I do, Your Honor.
All right, there is actually one more pretrial hearing before this thing goes to trial with jury selection on the 17th. That'll be next week. So that'll be the final opportunity for both sides to argue what should and should not be brought in during this highly anticipated trial. Kelly Hyman still with us. Donna Adelson is the next one to fall from the prosecution's standpoint. This case is different than what we saw with Charlie, her son, because he had a direct, one would argue, much more direct connection to the shooters. You've got the two hitmen, you've got Catherine McBanawa, and then Charlie's right there because he's the ex of McBanawa. Now we're one more person removed with Donna, and as much as it makes sense when you know the whole story, say, well, I bet she was involved. It's going to be a more difficult case, is it not, for the state?
Well, motive is going to be key, and that's going to be up to the state because the state has a burden to prove the case and prove every single element of the case. And so what they'll try and do in opening is show the motive, right? There's allegations that she wanted her daughter to be close to her, and that was the reason, the motive behind it, because allegedly there was this big custody battle between her daughter and the gentleman that was killed. And so that's going to be key, the motive, to try and show, no, that this was her motive. She had a real reason to want this to happen and potentially was the brains behind it, so to speak.
And this, this is being tried up in Tallahassee where the murder took place, obviously. And the folks up in northern Florida have a little different view of southern Florida than maybe the southern Floridians like yourself have of yourself. It matters in that if this case was being tried in Miami-Dade, it would be more difficult, but you have this more conservative jury pool, and the story that they're telling is the greedy, self-absorbed wife of a very successful dentist wants the grandkids, and she controls the kids. It is a great story, but is there going to be enough evidence there, enough there to get over the hump, do you think? Because Charlie was that much closer to the actual hiring and executing the hit.
Well, that's what's great about our jury system. You are innocent until you are proven guilty, and ultimately it'll be up to the state to do that, and they have to prove it. But ultimately the jury will look at the facts and the evidence presented and make a determination and say, yes, in fact, this is what happened, or say, you know what, the state didn't prove their case beyond a reasonable doubt because that's their burden, and we are going to find her not guilty.
Yeah, it's going to be a fascinating case. And then, of course, the question is Wendy next? What about Harvey? Is he in play as well? This is the case that just keeps going. It's been 10 years since the murder, and there's no end in sight to it with prosecutions. We'll be all over it from start to finish. Coming up, another one that seems to be just keeps going and going. Karen Reed speaking out. Wait till you hear this. She is talking about her involvement with the death of John O'Keefe. None, she says. She's asked point blank, are you sure you didn't maybe just hit him? We'll listen and hear from Karen Reed, her first interview since the hung jury in her case, coming up. Turning our attention now to Massachusetts, where defendant Karen Reed is speaking out as she awaits her second trial for the death of her Boston police officer boyfriend, John O'Keefe. Reed, who did not testify at her first murder trial, gave ABC News and Matt Gutman 2020 an exclusive interview in which she described finding O'Keefe dead in the blizzard and also doubled down on her allegations of a cover-up. Take a listen.
My eyes are peeled, and I said, he's right there. I jumped out the passenger side and I fell into the street. His eyes were shut and he had spots of blood in different areas on his face, and he was still, not stiff, but still. It was cold, I felt cold, but I didn't feel dangerously cold, and it was just an odd feeling to know that I'm okay, I'm not dying, but he's here with me and he's dying, and I can't warm him up.
That portion of it, she also would say to Matt Gutman, no, I did not. When pressed, did you maybe hit him? Did you maybe get drunk? Were you mad? She said, yes, I was mad. We were fighting, but I didn't hit him. I did not hit him with my vehicle. She's adamant that she didn't hit him at all and that this was a cover-up. The case stays on schedule. If it does, the second trial will be in January of next year. Again, that airing tonight on ABC. Kelly Hyman is still with us. This case is one that is being followed so closely, not only by people up there in Massachusetts, but around the country, and it has divided so many people. It's divided the communities. You got the pro-Karen Reeders and the pro-John O'Keefers who say Karen Reed is responsible. Her doing this interview with ABC when she still has another trial pending, obviously her attorneys gave the blessing because they're interviewed in the special as well. What's your take on that? Would you want your client out there?
This can be used against her. So my initial instinct was, why did this happen? Why would she let this happen? Because basically now she is testifying. So the state can use this, what she says, and get all this information. The timing is key in this. So in a sense that still she's got pending charges, why do the interview now? It can only potentially harm her more than it could potentially help her. So why not wait until potentially this matter is resolved? So as an attorney, I would tell my client not to do something like this because it could potentially backfire. I'll have to wait and see what happens.
After her conviction, after the hung jury, of course, a couple of jurors came out and said that they had unanimously decided not guilty on 2 of the 3 charges. At the end of the day, the judge denied a defense request to basically dispose of those 2 charges. And they argued that this would be double jeopardy, that indeed the jury did come to an agreement. They just didn't fill out the verdict form. At the end of the day, though, the judge said no, and agreed with the Commonwealth. Do you think, A, that this is going to go to a higher court, and do you think there is a chance it gets reversed, that the judge's ruling will be reversed and these 2 will be eliminated? We'll start with that.
As an attorney, you need to advocate for their client, and it was apparent that defense counsel was advocating for his client, even though the judge disagreed with what he was arguing. So absolutely, there could, if there are grounds, you need to have good, good faith basis on the grounds, but I could definitely see this going up and being appealed, because that's definitely going to be one of the arguments is double jeopardy. However, I could see the Commonwealth, of course, stating their position that it's not, and potentially go up to the Supreme Court. Ultimately, based on the case law, that the Supreme Court will look at that, and potentially they could say, we agree with defense counsel, or we agree with the Commonwealth, and she's going to be charged on all of these counts.
Yeah, it could end up being a precedent setting because there isn't really anything on point at this point that was brought up during this hearing to address this conundrum, if you will. Should the judge have done some investigation to see if indeed all 12 jurors, like bring in the foreperson or do something to get some clarity? Because even the Commonwealth, Prosecutor Lally says, yeah, we also heard from jurors that said the same thing. Should this court have investigated, or was it best just to let this go and stream upwards?
Well, it's always easy, as they say, to Sunday quarterback what happened beforehand, but the judge, based on what was presented to the judge, made the determination based on what was presented to them. Now, we could say the judge potentially could have asked all these different people the question and found out more information, but the judge believed that it had sufficient information in order to make its ruling based on the information that was provided.
Part of the reason, of course, that this jury had trouble coming to a conclusion is the same reason that people watching that have trouble, and that is the way that the investigation was conducted. The odd behavior from some of the people involved, getting rid of phones right before they were supposed to lead them over. The lead investigator, Trooper Proctor, lewd, horrible comments, texting his buddies about Karen Reed and nude photos. Is this case going to get any stronger for the Commonwealth the second time around?
Well, some would say the second time's a charm, but you never know. We'll have to see. I mean, they have to present their case, and it's going to be different jurors, and the jurors will look at the facts and evidence, and based on that, make a determination. Now, it's going to be 12 people of her peers, and so they can look at the facts and say, you know what? We've looked at this. We've listened to the Commonwealth's case, and she's 100% guilty, or she's 100%, innocent. But maybe they could potentially learn from some of the mistakes of the first case and see where they can kind of make sure that they do things potentially different from the first case.
The O'Keefe family has filed a wrongful death lawsuit. This is civil. This is a different burden of proof. How do you think their chances look in that endeavor, saying that Karen Reed, and they've also named the drinking establishments where they were before the incident took place in this lawsuit. What's your, without knowing all the details of the lawsuit, from your angle, could they be successful here? I mean, the insurance companies will pay out, likely representing the bars, but what about Karen Reed?
Well, the civil suit is going to be a lower burden. So that means basically that they don't have the same beyond a reasonable doubt burden in the case. So it's easier to prove the case. And it's also important to remember what is the damages. So in regards to a civil case, the damages are only going to be monetarily. And so as you were saying, with the establishment, potentially if there's maybe some type of insurance or something like that, then those will be monetary damages. It'll be interesting to see if she in fact testifies in this case, but with a lower burden, then it could potentially, more likely than a criminal case, could find someone innocent. As we think of the O.J. Simpson case, right? He was found not guilty of the crimes, but then their family filed civil lawsuits, and he was found liable in the civil lawsuits.
Absolutely. And it's very rare that civil cases go to trial. Usually they are negotiated out, but when they do, boy, the gloves come off. And we saw it with Johnny Depp and Amber Heard, which is the subject of our first edition of Victim to Verdict this weekend, Sunday night. Gotta watch that. And boy, if this one went to trial on the civil end, it would add a whole other layer to the Karen Reed saga. We'll, of course, watch every moment of this, and we'll see if that actual January trial date happens. Let's get a break here. Coming up, the biggest moments from opening statements in the cyclist road rage murder trial. They're dark today, but the jury is already working, and they get a long weekend to mull over what they heard in day one.
He's the man who beat me up for 5 years.
Two celebrities reveal their turbulent relationship to the world.
Go ahead. Hit me.
Victim to Verdict with Ted Rollins. New season premieres Sunday night, 8/7 Central.
Only on Court TV.
All season long, the greatest players in the world compete here.
I won't break. Welcome to the NWSL.
The NWSL is on ION. Find where to watch on IONNWSL.com.
Welcome back. Our attention to the state of Florida, where testimony is set to resume on Monday in the trial for a Florida motorcyclist accused in the shooting death of a bicyclist. That the two knew each other. 46-year-old Kadel Piedrahita faces a second-degree murder charge for the death of Alex Palencia. The victim was a cyclist with this group. They called themselves the Don Pan Riders, a group of cyclists. They would ride basically from Miami to Key Biscayne every couple weeks. The defendant was a member of the group, was kind of known to the group because he would ride his motorcycle alongside the bikers, basically escorting them, protecting them from angry motorists. And the victim in the case, Palencia, allegedly got into a dispute over an insurance policy that had lapsed. The two that got into this fight, the defendant and the victim, it was all over this insurance policy, and allegedly this all came to an end, and the defendant shot him. The other rider. He also tried to shoot a separate rider, a guy by the name of Cesar Sosa. Both sides gave their opening statements yesterday. Take a look at some of the highlights from both sides.
As the defendant approached them, Alexis Palencia noticed the defendant. So he rode up closer to the defendant on his bicycle while the defendant was on his motorcycle, and the two started exchanging some words. That exchange of words ended, and the defendant, while still riding his motorcycle, reaching out his right leg and kicking Alexis Palencia while he was still riding his bike. Now, that caused a couple of people to pull over their bikes and move to the side of the road. Those people being the defendant, Alexis Palencia, the deceased, Cesar Sosa, and the defendant's son. Now, almost immediately after they got off the bikes, the defendant and Alexis Palencia start getting into, sort of like a shoving, pushing match with each other. Cesar Sosa's in the middle, trying to break them up, and the defendant's son is standing nearby, not sure really what to do. You're going to hear that the defendant shouted, not even shouted, he commanded, he told his son, go get my gun out of my bag. And his scared son did just that. He complied with his angry, yelling father, went, grabbed the gun, and gave it to the defendant. Now you're going to hear, in the heat of the moment, Alexis Palencia, after seeing the gun, and somewhat incredulously, I might add, shouted, shoot, shoot. Members of the jury, unfortunately, that's exactly what the defendant did. He shot Alexis Palencia right in the abdomen. He shot Alexis Palencia while Alexis's hand was up. He was unarmed, and he was wearing nothing but a skin-tight biking suit.
Mr. Piedrahita's hit in the head with something hard. He's getting punched in the face with fist multiple times. And as that's happening, he feels he's outnumbered. His son, Mr. Galerito, tries to come in at one point and separate the fight, and that's not successful. He gets pushed out of the way. So in an attempt to stop it, he tells his son, "Sácala, sácala, take it out, take it out," asking his son to retrieve his firearm. But before his son could even open up the book bag, Mr. Piedrahita takes it from him, opens it up, and removes the firearm. But when he takes out his gun, he does not immediately point the gun at the individuals that were just attacking him. He keeps the gun by his side, so as to say, back off, I'm armed. He takes out his gun to show force, not to use force. And immediately after that, members of the jury, he sees another cyclist, Sept Sosa, hands a gun to Alexis Palencia. And immediately after that, Alexis Palencia extends his arm out to Mr. Piedrahita where he can see the end of the barrel. And at that point, he does the only thing that he can do to defend himself. He fires his words.
Two very different stories in front of this jury in the opening statements. You don't see that very often, where you have one version of the events being told by the state and another by the defense. when it comes down to, you know, material things like the other person had a gun or not, the state says he was unarmed, just wearing the biker suit, and the defense coming up with this other theory, Kelly Hyman here. This is interesting. It's really going to be a fascinating trial as it plays out because of the different versions of events. Does the defendant have to take the stand here to fill in the gaps?
It would be helpful for the defendant to take the stand because of the fact that there could be a potential self-defense of stand your ground. In Florida, you have a right to stand your ground, right? If you're feeling an imminent threat or that your life's in danger, and the defendant's attorney set that stage of showing the side of the story that, in fact, that he was hit, that he felt outnumbered, there was numerous people, he was trying to protect himself, and the only way to do that was to get a gun to protect himself. So it would be really helpful for him to testify, but ultimately that's going to be his decision. His attorney can say yes or no, but ultimately it's his determination of whether to take the stand or not.
Because in a self-defense case, the jury really does need to know your mindset and why you thought you were in danger of bodily harm or death, and that the only way to do it concretely is for the defendant to get on. That's why we see in so many self-defense cases, that's when, okay, defense, come on, and sure enough, they tell their version of events. The downside is, if that version is unbelievable, you're done, and it's always a risk. The others, the son, the witness, that Cesar, who was able to escape what was shot at, apparently, according to the state, they're going to be key as well.
The son's definitely going to be key because he could potentially say, absolutely, I tried to get involved and I got involved and I was pushed away. There was all these people. Obviously, my dad felt, you know, outnumbered. He was fearful at the time. He was being hit as well, and kind of play that to the jury and kind of tell the side of the story. But the state of mind really goes back to the defendant of what exactly was the state of mind, and it's going to be key in this case.
Yeah, we have already heard from a first responder, an individual, Marcos Diaz was his name, who came up, and he basically laid it out for the jury, sort of that chaotic scene afterwards, and and that's always compelling. The bottom line is someone's lost their life, and there was a plea deal offered in this case, which was denied by, turned down by the defense. But jurors are going to be in a difficult position because there isn't that, there's no video of this, and it is really competing versions of the same event. Does that lend itself, and what's your take, the fact that the prosecution did come out with a plea bargain offer that was turned down by the defense? Does that mean weakness in a case necessarily?
That could potentially mean weakness, right? That there's something else, so that the state says, hey, listen, our case is not bulletproof, right? There are some holes or some warts in the case, and that we're going to offer this plea deal. However, the defendant, it's their right whether they want to go to trial, and he did not accept the plea deal, and is ultimately leaving it in the hands of the jury.
Yeah, and if you want to go to prison for a little while to make it go away, took the risk, and here we are. They'll be back at it on Monday. Let's get a break in here. Coming up, we'll get a live report from Court TV's Cody Thomas on the